Well, good morning, everybody, and welcome to our talk on litigating equal pay claims. My name is Dale Martin. I'm here with Kieran Wilson. We're both broadly based employment and commercial practitioners, but we have a specialism in equal pay claims. I have been litigating equal pay claims for well over 20 years now, and group equal pay claims for well over 15. And I sense that we're coming into a period of time where equal pay is becoming more fashionable again. We're certainly getting more inquiries, and equal pay has been in the headlines recently. So the scheme of the talk today, we'll start off with the context and the current landscape. Where are we now? We'll then move on to an overview both of the legislation and the procedure. We're obviously talking about a relatively highly specialised process, and it often catches people out the extent to which equal pay differs from ordinary discrimination. So there are real traps for the unwary here, but looking on the bright side, there are also opportunities both for claimants and respondents. We'll look at the nature and the role of expert evidence, and most importantly of all, I think, is strategy. How, whether or not you're for a claimant or a respondent, how do you push forward the issues that you want to push forward so that the litigation ends up arriving potentially at an earlier settlement? How do you, if you're acting for a respondent, pace the litigation to try to exhaust the claimant to ensure that any settlement is on more preferable terms? Now, I've already said that that sex discrimination and equal pay work radically differently, but there's another feature to equal pay litigation, which is this, is that many of the cases arise out of group litigation, often involving hundreds, if not thousands, of women and sometimes men as well. But those authorities that result from that are applicable in individual cases. So it means that if you specialise in sort of city equal pay and city discrimination, that you're able to take the jurisprudence from the cases involving the women that might be on very low pay and apply them in the context of an equal pay dispute in a business context in terms of the square mile, and that often gives rise to significant opportunities as well. If you've got any questions, please do ask in the chat, and hopefully we'll talk for about 45 or 50 minutes. And at the end of that period of time, there will be time for questions at the end. So without further ado, I will hand over to Kieran, who will address the context and the current landscape.
Thanks, Dale. Morning, everyone. So before we get into the detail of the equal pay legal regime as a whole, I think it's sometimes worth taking a step back and looking at the landscape and asking ourselves, where are we now? We've seen a couple of quite high-profile legal equal pay cases in recent years, both involving the BBC. We had the Carrie Gracie case in 2018, which settled, and the Samira Ahmed case in 2020, which went to tribunal, and where Samira Ahmed won. A couple of interesting and noteworthy things about those cases, I suppose, in terms of what they're not, compared to a lot of the equal pay claims that we see. In that, to some extent, they're unusual because the comparator earnings were, first of all, available, because the BBC is required to publish pay information for high earners. And secondly, and relatedly, the comparator pay information was actually useful, because those people, the claimants and the comparators, were in sufficiently highly paid roles to be on that list. And secondly, an interesting point in respect of the Carrie Gracie litigation, which we're seeing, I think, in sex discrimination and sexual harassment litigation generally, more commonly at the moment, is the relatively open approach that we saw to confidentiality in that case. I think there does seem to be a sort of growing trend there, although that might be a slightly different topic for another day. It's not just the UK in which equal pay issues are live. There was the equal pay dispute between the US women's national soccer team and US soccer, which ran for a couple of years, and ultimately settled in August 2022 for $24 million. And then more recently in the UK, and I guess perhaps more relevantly for a lot of the people who are probably dialed into this call, is we've seen quite a bit of movement in some of the big retail equal pay cases. In the Next class action, we saw that Next lost on equal value after the independent expert assessment. The final string in the Next defence is the material factor defence, which Dale will be talking about in some detail, and that's due to be heard in the first half of next year. And then in the ASDA litigation, there are some media reports on the back of an email supposedly from the claimant's solicitors, that the independent expert report has come back and has rated the shop floor workers, who are the claimants in the case, higher than the distribution centre comparators, which may well pave the way to ASDA losing on equal value. And that would be a massive blow to ASDA in the context of that litigation. And no doubt the other supermarkets who are embroiled in equal pay litigation themselves will be watching their own class actions with a degree of worry in that respect. And then finally, on a more technical legal point, we've recently had confirmation, and I'll come back to talk about this in a minute, about Article 157 of the TFEU and the single source test being officially enshrined in UK domestic law. There's been a bit of a hokey-cokey situation there where it's not clear if we're in or out or in or out, but I'll talk about that in a moment. And then in even more recent news, just in case we needed a reminder of the potential impact of equal pay class actions, no doubt we will all have seen the headlines back in September involving Birmingham City Council issuing a Section 114 notice, in effect prohibiting all but statutory expenditure. And the council has said that a major factor in that has been the impact of equal pay liabilities flowing from a class action that went up to the Supreme Court back in 2012. The estimated outstanding bill there is something in the region of £700 million. We're talking big, big money. It shows the potential significance of these class actions. And between that and the supermarket litigation, I think, as Dale says, I think we can expect to see plenty of more equal pay class actions. It is fertile ground for litigation, and an area where lawyers will want to be in a position to hit the ground running. And then finally, just by way of context, mandatory gender pay gap reporting remains with us. It has since 2018. It's searchable online. I think I'm only going to spend a moment on this because one important thing to flag is that although gender pay gap reporting is interesting in the context of disparate earnings between men and women generally, gender pay gap reporting and equal pay are not the same thing. And gender pay gap information is often not particularly helpful in the context of equal pay and for equal pay claims, because it doesn't tell you who's earning what and where. It's far bigger picture than that. And so in the context of equal pay claims, very rarely actually useful information. But we do see that the most recent statistics show that the gender pay gap amongst full-time employees is 8.3%, and for all employees, it sits at 17.4%. And that significant difference, I suppose, is largely attributable to the comparatively larger proportion of women who work part-time, and so the figures are skewed in that respect. And then just briefly to show the historical context, if you like, of gender pay gap reporting and the gender pay gap, we can see that we've had a steadying decline over the years, with possibly a bit of a blip in 2020. It'll be interesting to see if that evens out, or if it's somehow pandemic related and it can be tracked into a more long-term trend. So, having neatly set the scene with the touchy-feely big picture, we turn to the legislation. I imagine we have people on this call with varying degrees of experience of equal pay, and forgive me if this is a a basic introduction for some of you, but I think it's always helpful to take things back to basics by way of reminder, particularly in circumstances where, as Dale pointed out, the equal pay legislation, although it finds itself in the Equality Act, it's rather different from your standard discrimination claim. So domestically, we find it within the Equality Act, which consolidated the Equal Pay Act of 1970, and it's in Part 5 of Chapter 3 of the Act. And there's one gateway to establishing equal pay, but sometimes we talk about there being three gateways. And I'll talk about these in a bit more depth later, but I think it's useful just to flag at the outset what they are, because it sets the scene for a lot of what Dale is going to talk about in terms of strategic considerations in the very early stages of litigation. The one overarching concept is one of equal work, or work that is equal, as the statute puts it. And there are three ways of showing equal work. The first is like work, which is where the work performed is the same or broadly similar as between the claimant and comparator, and where there are differences, those differences are not such as to be of practical importance. Secondly is work rated as equivalent, and that's where there's been a job evaluation survey in the workplace that rates the claimant's work as equivalent or at the same level of the comparators. And finally, there's work of equal value, which is undoubtedly the most complicated of the areas and where the big retail litigation is being run. And that's where, despite two people doing materially different jobs, or two groups of people doing materially different jobs, the work is equal in terms of the demands made on the claimant by reference to factors such as effort, skill, and decision-making. So just in terms of how an equal pay claim works legally, how it operates as a matter of law. Once equal pay is established, the equal pay claim involves importing a sex equality clause into the claimant's terms of work. And what that means is that the terms of the claimant's employment are changed in order to correspond with the terms of the usually male comparator. And that can either involve modifying terms that are already there, or inserting new terms that are absent altogether. It's worth pointing out that the equality that's provided for by the sex equality clause is in respect of all contractual terms. It's an area where we most obviously see in the context of pay, but in principle, that equality clause is in respect of all terms. And one of the central tenets of the approach to be taken in an equal pay claim is that it involves a term-by-term comparative analysis. You're not allowed to say, well, the overall package is equal, so that's fine. We take a term-by-term approach. And that's established very clearly by an early House of Lords case in 1988 called Hayward. In essence, the terms are treated as distinct provisions of the contract. You can't just lump together all terms that are to do with remuneration or pay-related matters. And there is some authority showing that where matters are dressed up as separate terms, for example, in the authorities, we've seen reference to things like guaranteed bonuses or attendance allowances was a classic one. But if these are in fact just facets of the wage work bargain relating to basic pay, they might well, for the purposes of an equal pay claim, simply be part of one term relating to basic pay for just doing your job, frankly. Where there are terms in the contract that are susceptible to comparison, and where they have sufficient content to make it possible to compare them, that is what should happen on a term-by-term basis. And the upshot of that in practice is that it is possible for a woman to bring an equal pay claim, and at the end of the day, what happens is that she receives more by way of total pay than her male counterpart comparators. from the original claim. And that's something that's highlighted by the Brown Bill case that is on the slide there. And that was a case in which the comparator's basic salary was more, but they had less favourable terms for unsocial hours. And once the less favourable terms were modified by the sex equality clause, overall the female claimants received more. And that might, depending on the terms that are in play in any given case or any given workplace, lay the ground for piggyback claims being brought by male colleagues who are seeking to claim parity with the women whose pay increases are a result of a successful claim that they brought. And then the final point to note on this in respect of the nature of an equal pay claim and how a sex equality clause works is that if the comparator leaves employment or they leave the comparator employment, so that you might say, well, they're not doing light work anymore, they're not a valid comparator anymore, the claimant's pay will not reduce in those circumstances. The Sorby case that's on the slide there was to do with a male comparator who went on to be promoted into a supervisory position, and the employer sought to argue that the entitled to equal pay in effect ended at the point that that promotion took place. But the court said, no, that's wrong. And the same applies whether it's as a result of a promotion or as a result of the comparator leaving employment altogether. Finally, a quick word on the status of EU law. Article 157 of the TFEU has always been a notable source of the right to equal pay and equal pay law in the UK. It's been found to be directly effective in all three types of equal pay claim. There was some uncertainty in respect of equal value until relatively recently, but the CJEU in K and Tesco confirmed that in principle it applies in equal pay claims. It is of importance in equal pay litigation most significantly because it's the basis of the single source test, which allows for broader equal pay claims to be brought than are permissible under the domestic legislation. And I mentioned previously that there has been a bit of a question mark over the future of Article 157 in UK law, because it originally formed part of retained EU law under the Withdrawal Act. It was potentially up for the chop again under the retained EU Law Revocation and Reform Act 2023, which abolishes directly effective EU law rights from the 1st of January 2024. But very recently, well, the government indicated in September that they would bring forth secondary legislation securing the status of Article 157 as part of domestic law. And in just the last few weeks, the government have published draft regulations in the form of the Equality Act 2010 Amendment regulations to do just that. They've not yet been brought into force, but their effect from the 1st of January 2024 will be to enshrine the single source test within the comparator provision in section 79 of the Equality Act. When the government announced they were going to do this, there was a bit of question of, well, how are they going to do it? And we now have the answer to that, which is by amending the Equality Act directly. So the single source test will remain part of domestic legislation. So that's the legislative, a whistle-stop tour of the legislative background. And Dale's now going to come on to talk about some more strategic considerations.
Thank you very much. Well, the first point that I want to discuss is when is an equal pay claim not an equal pay claim? One of the real traps for the unwary is actually the extent of the equal pay jurisdiction and how it interrelates with sex discrimination. And Hosso is actually a really good example of what can go wrong here. Hosso was a case where a claimant claimed equal pay in regard to a payment that was higher in respect of a male comparator. But the problem was that the tribunal made a finding that the pay concerned was discretionary pay. It wasn't actually related to any contract term at all. And so the claimant found herself in a position where her claim didn't relate to a contract term. The case went up to the Court of Appeal. the Court of Appeal decided that the claim was essentially a claim for sex discrimination because it arose out of a discretionary payment. It didn't relate to a contract term. The result of that for the claimant was, because she filed her claim in between the 3-month time limit for sex discrimination claims and 6-month period for equal pay claims, that sadly her claim was out of time as a sex discrimination claim because that's what it was. And it really highlights the dangers, particularly early on when you're still getting to grips with what the case is about. It might not have been properly researched at the time that you're formulating it, as to what sort of case you're actually dealing with. This case is often paired with a case called Hoyland and Asda, where a sex discrimination claim failed because the reality of the term was that the payment was never withheld from anyone, so it was just a contractual bonus. Obviously, the advice here is, if you're able to, plead them in the alternative, and plead them at such a time that enables you to be in time both under the equal pay jurisdiction and under the sex discrimination jurisdiction. And then just finally on this case, there was even some disagreement between the Lords Justices, Stanley Burnton and Mummery, as to what jurisdiction applies in circumstances where a benefit is conferred by a contract, but it's a discretionary benefit. Stanley Burnton saying that's in the sex discrimination camp, Lord Justice Mummery saying that's to be decided another day. The middle bullet point contains where I think the law is at on this. But as I say, there is no harm in being cautious and being timely if you might have to grapple also with a sex discrimination complaint. So moving on, looking at seeking information, it may well be that you're all familiar with Section 77, which bans terms that seek to prevent employees from asking for or disclosing information. A couple of points on this. Sometimes overlooked. The first one is that it relates to all protected characteristics, but it's also important to note that it relates to conversations between colleagues, as well as direct requests for information from the employer. Although there are limits, it won't apply in the event that a disclosure is made simply to try to get a better offer. It is actually about being rooted in the potential for pay discrimination. And then I also just wanted to deal with Tesco Stores and Element, which is a really good example of how jurisprudence can be generated in the context of low-paid mass claimant employment, but it can be very useful in the city executive context. In Tesco and Element, it was, if I may say so, a relatively classic situation in mass equal pay, where the particulars of claim that were issued on behalf of each claimant read in standard form and didn't actually tell one very much about the sort of claims that were being advanced. And there was no identification of individual comparators. And the claimants applied for very substantial disclosure, which was given by the tribunal, lists of employees with job descriptions, pay and contracts, gender breakdowns, lots and lots of information. And the respondents sought to resist that on the basis that essentially they'd been met with a largely pro forma claim and that the merits of the claim hadn't been established. And the EAT essentially stated that one has to bear in mind the difficulties that individual claimants have in enforcing their rights. They might not know what comparator groups or potential comparator groups even are paid. And therefore, all one is asking at the initial stage of proceedings before making these disclosure orders is there a reasonable prospect of success? And essentially, what that test means is there a reason for believing that there isn't? Because obviously one's at a very early stage. So there's quite a lot of power on the part of claimants to be able to seek information in equal pay cases, even if they're not able to state with particularity what their comparators are going to be, or what the comparator roles are going to be. And then finally on this slide, I did want to mention audits, because equal pay is increasingly a high stakes game. And one respect in which that is true is that the default order in the event that a respondent loses an equal pay case is that they should have to do an audit. And that is a surprisingly open an open process where the results of it need to be on the website for 3 years. All the individuals whose data contributes to it have to be informed. They have to be told where they can get a copy. There are exceptions, but generally speaking, one needs to send it to the tribunal, and there are penalties for non-compliance. And so that really does alert people to the possibility that there may be equal pay issues. And obviously, it could give rise to significant further claims resulting from that initial successful claim. Let's move now to this issue of comparators. I mentioned that it's possible to get disclosure at a relatively early stage, potentially relating to broad range of comparators, but it's probably instructive at this point to take a break from that and consider, well, who are the potential valid comparators? And there really are two routes here. The first is the domestic one, the second is the EU one. As to valid comparators domestically, you're looking at section 79. Does the claimant and the comparator work at the same establishment or work at different establishments where common terms and conditions apply? Now, in relation to that test, work at different establishments where common terms and conditions apply, that has been very substantially watered down in the authorities, particularly Dumfries and Galloway and North. But over a course of decades, actually, it's a threshold test with limited function. And the cases where it won't be met will be exceptional. And essentially, you're not comparing the detail of the claimant's terms and the comparator's terms, but you're asking whether or not people that do the claimant's job and people that do the comparator's job have broadly similar terms. In order to assist in working that out, one would ask whether or not, if the comparator worked at the claimant's location, whether the comparator's terms would be different. And if they wouldn't be different, that indicates that there's no specific geographical tie to what the comparator's terms are, and therefore that there's no reason to take them out of consideration. So in Asda and Brearley, the court determined that if the distribution workers at the warehouses were instead employed next to the stores, their terms wouldn't be any different, and therefore there was nothing particularly special about their terms, and the comparison could go ahead. But where this has been blown wide open, really, is the EU law test, where the difference in pay is attributable to a single source, which has power to rectify the difference. And that really does open up the prospects, particularly in the city cases, for comparisons internationally. I tend to find it's always the New York office where people seem to be paid the most, but granted, sometimes it can be on the West Coast. And the development of the law in this area has eluded most respondents from being able to defend the claims, because basically what you're looking for is whether or not there is, even if indirectly through subsidiary companies, a board of directors who could, if they wanted to, address the disparity in pay. The one case that's worked for the respondent was actually Robertson and Defra, whereby legislation, two different government departments had different entities that were responsible for the setting of pay, and therefore it was held that cross-departmental comparisons weren't actually allowable under the EU test, but it ordinarily will be. And over the years, the scope of valid comparators has broadened out very significantly. And so that can mean, if we can just move on, please, Kieran, that can mean that one ends up in a situation where individuals want to change their comparators when they know more about the claim. And one of the things that respondents sometimes like to do is to if possible, cause that to give rise to preliminary hearings, so that amendment applications and time limits and all the rest of it can be considered. It's a way of pacing the litigation so that one doesn't get to trial too quickly. And Preston Michel tells us that ordinarily you will be talking about a new claim if you're trying to introduce into proceedings a comparator that does a different job. So not if it's just substituting a man that does the job for another man, for example, because one of the men has a longer period of service but the other one doesn't. And that also holds true in relation to claimant roles as well. So in my case of two sisters, it was acknowledged that changing the claimant role would give rise to a new claim, but it would also do so in the event that the claimant roles changed. And that's true both in relation to qualifying period, i.e. whether the claim's brought in time, or the arrears period. Both of those would have to be considered by reference to the date of the amendment application rather than the date of the original ET1. And there's also an open question on the authorities at the moment as to whether or not you'd have to consider time limits on any amendment application at the same time as the rest of the amendment application. Kent and the presidential guidance suggest yes, and so does my case of Amy Services and Aldridge, but there is actually authority now stacking up on the other side. And that obviously has a relevance as to whether or not it might merit a separate hearing, or it might merit all being wrapped up and dealt with later. So moving on, just dealing generally with the rules as to jurisdiction. And this is, again, one of those areas where there are traps for the unwary, because it works very, very differently from sex discrimination, actually, because equal pay predates sex discrimination, and it was done by reference to entirely different time limits. So the standard case is that you have to bring your claim, or now notify ACAS, within 6 months from the last day of the employment or appointment. And it's important to note that's not the same as the employment relationship. It's the employment contract to which which one is referring to there. Then you've got the stable work case introduced as a result of EU jurisprudence, that if there's a stable working relationship that comes to an end, the claim has to be brought within 6 months of that. There's separate extension for concealment, mistake and incapacity, but there's no general just and equitable provision here. That often catches people out. And bear in mind that one of the options for equal pay, because it is a contractual remedy, is to bring the claim in the civil courts, where you don't have to worry so much about the qualifying period of 6 months. It's more the back period of 6 years that has to be the focus. So let's now have a look at some of the case law that underpins these the jurisdictional time limits. Moving on, as to the standard case, Cumbria and Dow tells us that there will usually be a break that triggers the equal pay time limit for a standard case when new terms and conditions are signed. So people can sometimes sign new terms and conditions thinking that they're carrying on in their job, but actually what they do is they set a trigger point for equal pay claims, because it brings one contract to an end and starts another. Now, when that case got to the Court of Appeal, the court then wanted to consider stable work in circumstances where, obviously, if you've got the same job but just under different contracts, that usually falls under the banner of a stable work case. The leading case in that area is Preston and Wolverhampton, where there are a series of contracts with gaps in between, but it was the same kind of work, and the court held that essentially that's a stable working relationship. Now, there were a lot of cases, certainly at Court of Appeal level and above, about the fact that what you're looking for is whether or not the nature of the work changes. But at EAT level, the EAT's recently gone further in Barnard and Hampshire Fire. In that case, there was an evolutionary change to the role, a number of changes, including some promotions. And it was held that none of that broke the stable work case. Just one point on TUPE is that if there is a TUPE transfer, what you're looking for is whether or not the whether or not the claim is submitted within 6 months of the transfer, because essentially the pre-transfer claims will be out of time unless they're filed within that time. So that liability transfers over to the transferee but the right is not enlarged, so the time limit starts to run. And as I've said before, there's no just and equitable time extension. And then just briefly in relation to multiple claim forms, the bottom has really fallen out of the market since I was at the Court of Appeal on this. And essentially, claims used to have to be based on the same set of facts in order to be presented on the same claim form. But actually, the rules are now much more permissive. What we're talking about now is if claims give rise to common or related issues of fact or law, or if it's otherwise reasonable for their claims to be made on the same claim form. Now, it does mean that the claimant will have to allege their claim, and that has been picked up in historical case law, Hamilton and NHS Grampian. But the broadening of Rule 9 has meant that it becomes easier for claimants to present their claims together if that's what they want to do. So I'll now hand over to Kieran, who will deal with looking at some of the details in relation to the gateways for equal work.
So turning first to like work, which I guess in some respects is the simplest of the gateways. The statute sets out what like work is. It's where the work is the same or broadly similar, and to the extent that there are differences, the differences aren't of practical importance. Those are two separate questions, which the tribunal needs to consider individually. And importantly, in the focus here is on work that's actually done, rather than on what the contract of employment says is being done or what might be required of an employee. And the Dorothy Perkins case demonstrates that. That doesn't mean that the contract is irrelevant, but it is important to be alive to what actually happens day to day on the ground, which will often mean that in a like work case, the witness evidence will be particularly important. And it's also important that the whole job has to be taken into account. It's the role itself that needs to amount to like work. You're not able to hive off parts of a role and say, well, that amounts to like work, so it establishes the claim. If there are parts of the comparator's role which are not performed by the claimant, for example. And I've put on the slide there the final bullet point, some of the things that might be taken into account in deciding whether or not there is like work. And to some extent, there can be an overlap in deciding whether there's like work and deciding whether there's a material factor. Things like training and qualifications can be relevant to material factor, although they are obviously two separate aspects of the case. Work rated as equivalent is a gateway which is either available to pursue or it's not. And the reason for that is it requires there to be a job evaluation study to have been carried out in respect of the relevant workplace. It has to be a survey that satisfies the statutory criteria in section 80, subsection 5. The Tesco and Element case from last year told us that. Most commonly, it's seen in large public sector organisations like local government and the NHS, but some large private sector employers might carry them out as well. And some people might argue that there is a strategic benefit to an employer carrying out a JES, because as long as it's being carried out honestly and appropriately, it can act as a defence to an equal value claim. And it also gives that employer more control over the value to be attributed to each role with more limited scope for challenge. Other people might argue that it creates a rod for the employer's back that it would rather not have created several years down the line when it's stuck with the findings of the study that was carried out previously. There are various different ways of carrying out a JES. I'm not going to go into them now. The most common way of doing it is having a point system, attributing points to different factors, skills and job characteristics. The points are totted up, and those that receive the same number of points are equivalent, and a claimant can bring a claim in respect of a comparator who's rated either equivalent to them or lower than them. there's various guidance as to what needs to be done in order to satisfy the statutory requirements of fairness and transparency. The overarching point is that the criteria needs to be, or the survey needs to be thorough in its analysis and capable of impartial application, and has to take into account all factors relevant to the work. As long as the factors are objective in themselves, objectively applied, and free from inbuilt discrimination, generally that will be enough to satisfy the relevant criteria. A potential trap for the unwary is one of inbuilt discrimination, placing too much emphasis on a trait which might be more characteristic of one sex or the other. For example, physical strength might be more characteristic of men. Manual dexterity, on the other hand, might be more characteristic of women, and there's a risk that you can bake in discrimination to your JES if you're not careful. Final point to note is that it doesn't have retroactive effect. You can only assert that you are rated as equivalent after the JES has been brought into effect. But it is worth noting that if a JES is done and not brought into effect, it might still be relied on as evidence if you get your hands on it in an equal value claim, and it would likely be disclosable in those proceedings. So equal value then, as I said, by some stretch, the most complicated of the gateways to asserting equal work. It's complicated, it can run for many years, and it can be very expensive to run. It's often utilised by respondents to draw out proceedings in the hope of obtaining favourable settlements. Claimants will often not want to be pushed into the equal value procedure, sometimes asking for the likes of, say, like work to be determined first, but sometimes that's not viable on the basis of the claim that they are trying to bring. A lot of you will know that much of the high-profile retail litigation that's going on at the moment have been fought on the basis of equal value, and it involves a comparison between jobs which are often on the face of it not at all alike. For example, between workers in supermarket distribution centres and those working in store. So this is the gateway that means that you can't simply say, well, they're doing completely different jobs, so there can't be an entitlement to equal pay. And as I'll go on to talk about in a minute, there will very often be a need for expert input in these cases in order to carry out the necessary comparison between the jobs, in order to figure out if they are actually of equal value. There's a statutory mechanism for appointment of an independent expert, but very often parties also look to instruct their own experts in these scenarios. One thing that is worth being clear about, and that I think people often forget, is that work can only be of equal value if it's not like work and it's not work that's rated as equivalent. So in that sense, it's a fallback position. And that's why I say strategically, sometimes claimants will seek to avoid being pushed down the equal value procedure by emphasising this point, and suggesting that like work should be determined first. And the upshot of that is that the substantive claim is likely to get on much more quickly. And also importantly, other allegations of discrimination, like underlying sex discrimination claims, may well get on more quickly as well in those circumstances. So in terms of the procedure to be followed, there's statutory procedure that takes part in 3 stages. There is an indicative timetable for completion of the procedure of 25 weeks where there is no independent expert, and 37 weeks if one is appointed. Now, anyone who has been involved in any form of tribunal litigation will know that that's an ambitious timetable for even the most simple employment claim, and you'll be unsurprised to hear that timetable is not one that is typically met. As I've said previously, these cases rumble on for years. The stage 1 hearing is in many ways a case management hearing for the equal value procedure. It involves the tribunal deciding what it's going to consider and when, as well as whether to appoint an independent expert. There might be preliminary issues to consider, like whether there's a defensive material factor and when that should be considered, or whether there is an applicable valid JES that might shape the direction of the litigation in a different way. And it's also important to note that at that stage, stage 1, parties have an opportunity to make representations about instructing their own expert. And that is the case even if the tribunal is not going to order an independent expert. Stage 2 only happens if the tribunal has ordered an independent expert. It takes place before a full tribunal. And it's primarily an opportunity for the parties to resolve disputes of fact, so that those agreed facts can go to the expert and they can work on the basis of those facts in order to reach their conclusions on equal value. Where there is no agreement on the facts in question, the tribunal at that stage will need to make determination on those facts. And then finally, at stage 3, the question of equal value itself is determined. And at that hearing, the parties can challenge whether an expert's report should be admitted in evidence at all, although those challenges rarely succeed. And if the report is admitted, there's an opportunity to challenge the conclusions of the report. And in practice, what that often amounts to is a challenge of the methodology that's been adopted, since the independent expert will have been working off the basis of the agreed or determined facts from the stage 2 hearing. And that will often, though not necessarily, be done through the commissioning of a party's own expert report. The independent expert's report doesn't necessarily have any special precedence over a party commissioned report, but in practice, it is, I think, probably more common for a tribunal to prefer the conclusions of the independent expert. And I think that being the case, it's worth a note on the independent expert themselves. I think it's probably fair to say that independent experts vary in quality. There are undoubtedly some very good ones. But the fact that not all of them are necessarily very good can be frustrating for respondents in particular, because it is subsequently very difficult to challenge their conclusions. So employers need to put their best foot forward in providing the material to guide them along the way in reaching the conclusions that the respondent wants them to reach. Often the best thing that the employer can do to do that is, after the stage 1 hearing, but well in advance of the stage 2 hearing, is seek to impact the methodology that the expert is going to use in the form of proposed scoring guidelines and the basis for preparing the job descriptions, which will go on to be the basis of the agreed facts. You try in those circumstances to get an emphasis placed on the things that are going to result in a more favourable outcome, in order for them to look at it in the way that you want them to look at it. And even if you don't succeed in impacting the methodology in quite the way that you wanted to, you can seek to challenge at stage 3 the methodology that was adopted, or to suggest that the independent expert has in fact failed to follow their own methodology altogether. And as I said, that's typically done by having your own expert's report, and ideally that party expert will have been involved in the litigation from a very early stage. It probably goes without saying that that can be quite a laborious task, getting all of that done, getting all of the information together, getting job descriptions, and reviewing and identifying other documents that are relevant to the comparison exercise. Given that in effect it's an analysis of what the job's involved in practice, a lot of management input is required in order to be able to best present what the respective jobs involve. And I think in cases like this, small things can make big differences. And lay clients need to be aware of the fact that these things are time consuming and laborious, and they need to be prepared to put the time into fighting these proceedings. Now, in the big class actions, it's very clear why they've got an incentive for doing that. But in smaller cases, you might not necessarily see that same appetite for getting the sleeves rolled up. But it is something that is very important in these cases. So that's a slightly more detailed overview of the way of asserting a claim in law. And Dale's going to turn now to focus on what options are open to an employer, I suppose, primarily once equal work has been established, and also some of the wider strategic considerations.
Thank you, Kieran. I can't yet see any questions in the chat. So what I'm going to do, if we don't see any questions, is to use more of the time to deal with strategy at the end, because there's a few important observations I want to make. So we're dealing now with the case where essentially we're looking at material factor, potentially because the claimant has succeeded in establishing equal work. And it's important to note that this need not necessarily come at the end of a case. In fact, sometimes claimants want to bring it forward because they think that the employer is not going to be able to establish material factor, and then they think that they'll get a better settlement in relation to the prospects of them establishing equal work. But let's look at the ingredients. Section 69 provides that where the responsible person shows that the difference in pay is because of a material factor, reliance on which does not involve treating A less favourably because of A's sex than the responsible person treats B. And the burden is on the employer. There's an argument that in relation to sex taint, the Section 69 has actually altered that bit, but subject to that, the employer has to show the reason for the disparity, and the reason must explain all of the difference if it's going to be a complete defence. And it's really important to fix in one's mind at an early stage that there's essentially two different directions depending upon whether or not, excuse me, the reason involves treating A less favourably because of A's sex. If there is a sex taint, then there will be a substantially different approach. On the basis that there isn't a sex taint, the tribunal is simply looking for the question as to whether or not the reason that's advanced has ceased to operate to explain the difference. So it's a much lower test. Let's have a quick look at some of the possible material factors. I'd say this is just my favourite 10. There is a lot of law behind each of these, sadly, and there isn't the time in this talk to explore them all. But the issue that tends to recur is whether or not there is a sex taint involved, which means that a more objective standard of justification is required, or whether or not there is an inbuilt discrimination in the marketplace that means that you can't rely on the disparities that have arisen between the claimant and comparator. So, for example, in relation to length of service, are more men with longer service in the organisation, and therefore it benefits them. In relation to inbuilt discrimination, so far as market forces are concerned, is the reason why a claimant role is commands a lower salary in the marketplace simply because it's always been regarded as women's work, and if so, relying on market forces in those circumstances, Ratcliffe and North Yorkshire Council is not going to be a permissible way forward. But it is important to note the one at the bottom, mistake of fact or administrative error. Equal pay is not a fair pay statute. It's sometimes mistakes are made and they're non-discriminatory mistakes. Let's have a look at sex taint, because in some ways, if there's one thing that I really would like to be taken away from this section, it's just how broadly these principles can operate and how much difficulty that can create for the employer. So if you've got a provision, criterion or practice, or if you've got a situation where two groups of employees are doing work of equal value or other equal work, and there's a sufficient disparity between them, tainting by numbers, or where pay lacks transparency for which the ECJ and Danfoss, then the employer will have to show that the factor is a proportionate means of achieving a legitimate aim. And that basically means that it was reasonably necessary, and there's often a debate between the parties as to whether or not there could have been another way of achieving the aims that the employer wanted to meet without giving rise to the pay disparity in question. And the really important point is how small disparities in how people are treated can give rise to the need to justify by reference to sex team. So, for example, in McNeil, it was conceded that a 3% difference in terms of the outcome of a long service pay scale between men and women, a 3% difference might give rise to the need to justify. In London Underground and Edwards, even though there was, even though only the claimant herself couldn't comply with the PCP, and there were 2,000 odd other people that did her job, it was held in the circumstances that gave rise to a need to justify a sex tainted material factor. Grundy and British Airways, 99.53% of women could comply with a requirement versus 99.9% of men. That gave rise to a sex taint. So it's often important to look under the numbers, to look at the numbers, to see what the trends reveal, to see if there's a possibility for getting those sorts of arguments off the ground. And that means that when you're looking at length of service, when you're looking at market forces, when you're looking at pay protection, you've got to think about whether or not it gives rise to these sorts of disparities. Let's move on, given the time, to consider sources of evidence, because one of the really important things here is that although you might be talking about a period of claim of 6 years, in fact, the decisions that give rise to the disparities that existed and continue to exist between claimant and comparator may be earlier. And particularly if you're acting for a respondent and you want to play a longer hand, having regard to the fact that people leave, people retire, people forget, data gets destroyed, it's really important at an early stage in the litigation to look at these bullet points and think, how far back are we going to need to go in order to be able to explain differences in pay between a claimant and a comparator? And what can we do to secure that information now, particularly if we're up for a longer fight? So we've put some elements on the slide here, and I suppose another important point here is that when people are sitting in remuneration committees, they always think their deliberations are confidential, but they very rarely meet the threshold for privilege. And so with respondents, there's often quite an uncomfortable discussion that one has to have about the fact that the mere fact it was regarded as confidential within the organisation doesn't actually mean it's confidential in terms of it not being disclosable in the litigation. Let's move on to the strategic considerations, please. And I just want to take a step back really and consider a couple of classic cases through which one can talk through these points. So the first one is your single city exec who claims light work with a number of men and equal value as an alternative. If you're acting for the claimant, you might want to put light work first because it tends to be quicker. The respondent is likely to argue for trying to bring forward equal value on the basis that it will then take a couple of years to resolve. And it's important to consider how one positions those arguments at that important first preliminary hearing, because that's likely to dictate the path of the litigation. And there's also the question as to whether or not there's a material factor, and whether if you're acting for a claimant, you think that bringing forward the material factor might force the respondent's hand because it actually doesn't explain the difference in pay, or there's an argument about a sex taint. Then consider mass equal pay litigation. If you're acting for a respondent and you want to hold back the gates of the litigation, can you run preliminary hearings about the comparability of comparators, whether or not they fall within the tests that we've described, whether there are time points, single stable work relationship points, whether there's a pay gap in the first place, having regard to the the pay elements which fall to be aggregated and those which don't? Are there amendment applications that can be dealt with to pace the litigation so that one doesn't end up in a situation where one gets too early to the substantive questions that might result in a greater recruitment of claimants? Sometimes with equal pay, it's more about containment. It's about confidential settlement, if possible, in order to ensure that other people within the organisation don't seek to piggyback off of the results of any successful claimant. So, for example, people seeking parity with a claimant, once the comparator and the claimant have been established as having done equal work, there can be ratchet effects across the organisation, and that's why the considerations on the slide at the moment become very important, particularly in equal pay cases. Katie Harris asks, do parties ever agree to appoint a single joint expert, i.e. not one appointed by the ET? So this is obviously in the context of equal value. The answer tends to be no, because in the event that the respondent wants expert evidence, it's going to want the different stages that are provided for by the independent expert. The claimant ordinarily is not going to want to pay for an expert in circumstances where the state will provide one at no cost. And also the claimant might think, and might be right to think, that in certain circumstances, given the background of some of the IEs, that they might get a sympathetic application of the relevant scorings. So one tends to find that less. One tends to find more that respondents in particular will want to appoint and seek permission to lead party expert evidence in order to challenge the methodology or conclusions of the independent expert, and that tends to be what one finds. Emily Knight asks, what are the penalties for failing to comply with an equal pay audit? They are grim. The tribunal, essentially, there are fines, and the tribunal can enforce along the way to ensure that the equal pay audit actually does take place. Now, I keep on looking to see if there are cases on this, and sadly, there still aren't. It's an underused part of the tribunal's jurisdiction, and I can't readily understand as to why, but the tribunal will want to be satisfied not just that the audit has been done, but that all of the relevant requirements have been satisfied, including the notification requirements. I've got a question in relation to equal value claims. How much materiality have ETs, the EAT, given as a potential objective justification where the explanation for pay disparity is because there's a lower paid non-union environment versus better paid union workplace? That's a great question, and it's one that I didn't get a chance to explore during my exposition in relation to material factors. So this is essentially Coventry Council Union Intransigence. In that case, the council wanted to explain that the reason why the men had been substantially better treated over time was that the union, quite possibly the very union that was suing them on behalf of the women, had pressed a lot harder for the male occupational roles than in relation to the female occupational roles. And that went down like a sack of spuds, I'm afraid. Essentially, the employer cannot blame the union, whatever the industrial realities, for the fact that a substantial pay disparity between a claimant and the comparator has arisen as a result of that. Now, there is an Irish case called Kelly that went to the ECJ that indicates some flexibility on the margins of that. And in relation to that, there may be some scope, but the domestic authorities are very much against being able essentially to rely upon collective bargaining units. I'm going to also deal with this question about what's my view on the future path of the next case and how quickly it may come to a final denouement. My understanding, and I appreciate the theatricality of the final flourish to that question. My understanding is that the material factor hearing is in May, and then finally, oh, sorry, I'm being asked a question. Where would you find an independent expert? The answer is that the Employment Tribunal appoints them from a list, and it can actually take a very long time to get in the queue. Until relatively recently, there are only 24 of them. And it's actually an area where it's very difficult to get people. The pay levels, as I understand it, aren't very high, and there is essentially an issue with the amount of work that they take on. The fact it's possibly, in any event, only a part-time role, so it can take them a very long time to turn a report around, but they're appointed by the tribunal with the involvement of ACAS. It can also be very difficult, while I'm on the subject of the difficulty of tracking down experts, it can also be quite difficult to find a party expert. It's quite difficult to find people with the requisite skills, quite apart from the issue of whether or not you are in an industry that your expert is familiar with, which is often one of the elements. So from me and from Kieran, thank you very much for your time today.
Thank you.